ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಮೂಡಾ ಕೇಸ್ ವಿಚಾರಣೆ ಮುಂದುವರೆದಿದೆ. ಸಿಎಂ ಸಿದ್ದರಾಮಯ್ಯ ಅವರ ಪರ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ವಾದವನ್ನು ಮಂಡಿಸಿದ್ದಾರೆ. ಸಿದ್ದರಾಮಯ್ಯನವರಿಗೆ ಬಹಳ ಕ್ರೂಷಿಯಲ್ ಡೇ ಇವತ್ತು, ಬಹಳ ಮಹತ್ವದ ದಿನ. ಇವತ್ತು ಸಿದ್ದರಾಮಯ್ಯನವರ ಮೂಡಾ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸಲ್ಲಿಸಿರುವ ರಿಟ್ ಅರ್ಜಿಯ ವಾದ ಪ್ರತಿವಾದಗಳಂತೆ ಆಗಲೇಬೇಕು ಮತ್ತು ಇವತ್ತು ಆದೇಶ ಬಂದರೂ ಆಶ್ಚರ್ಯ ಇಲ್ಲ. ಹಿಂದಿನ ಕೇಸ್ಗಳನ್ನು ಈಗಾಗಲೇ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ಉಲ್ಲೇಖ ಮಾಡ್ತಿದ್ದಾರೆ. ಆರ್ಟಿಕಲ್ 356ರ ಬಗ್ಗೆ ವಾದವನ್ನು ಮಂಡಿಸ್ತಿದ್ದಾರೆ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಪರ ವಕೀಲರು. ಈ ಕೇಸ್ ಆರ್ಟಿಕಲ್ 356ರ ಅಡಿಯಲ್ಲಿ ಬರೋದಿಲ್ಲ ಅನ್ನೋದನ್ನ ಬಹಳ ಸ್ಟ್ರಾಂಗ್ ಆಗಿ ಪ್ರಪೋಸ್ ಮಾಡಿದ್ದಾರೆ. ರಾಜ್ಯಪಾಲರು ಜನರಿಂದ ಆಯ್ಕೆ ಆದವರಲ್ಲ, ಅವರು ನೇಮಕಗೊಂಡಿರೋರು. ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ಸಂಪುಟದ ನಿರ್ಣಯವನ್ನು ತಿರಸ್ಕರಿಸಬಹುದು, ಆದರೆ ಎಲ್ಲ ಸಂದರ್ಭದಲ್ಲಲ್ಲ. ಸಂಪುಟದ ತೀರ್ಮಾನವನ್ನು ರದ್ದು ಮಾಡೋ ಅಧಿಕಾರ ಅವ್ರಿಗಿಲ್ಲ. ಅವ್ರು ತಿರಸ್ಕಾರ ಮಾಡಬಹುದು, ರದ್ದು ಮಾಡಂಗಿಲ್ಲ. ಸಂಪುಟದ ಶಿಫಾರಸನ್ನು ಒಪ್ಪದೇ ಇರಬಹುದು ಅಂತ ಜಡ್ಜ್ ಮಾತನಾಡಿದ್ದಾರೆ. ಅದೆಲ್ಲ ವಿಚಾರಗಳ ವಾದ ಪ್ರತಿವಾದ ನಡೀತಾ ಇದೆ ಹೈಕೋರ್ಟ್ನ ಕೋರ್ಟ್ ಹಾಲ್ನಲ್ಲಿ. ಈಗಾಗಲೇ ನೇರ ಪ್ರಸಾರದಲ್ಲಿ ನೀವು ಗಮನಿಸಿ.
Observation that in such cases it may be possible to contend that there is an apparent bias. The next line says, but we are not called upon to decide that. Anomalous. The decision of the court turned down 11.3, not on bias, but because there was an express finding that the decision of the council was ex facie irrational. This is 11.3. And because it failed to consider Lokayukt report, as my lord just pointed out, recommending registration of an offence which was relevant material. Please note paras 24 to 31. Now I'll just read this part, then I'll read those paras. Let me finish reading this part. I'm applying it immediately to my case.
Yes.
Applying this to my case, there must be overwhelming material based on which a prima facie case is clearly made out. And despite this, prior approval is refused. That's as simple as that. Whether the cabinet says don't give sanction, material says to the contrary, the governor says this is the material, you are wrong, then your lordship will not grudge him the power. But he can't just walk in and apply an automatic presumptive test.
There the cabinet had fumbled in MP.
By not looking at this Lokayukt
report.
The observations at 32 of the MP sanction order of the governor dated 16/8 have nothing to do with bias and are rendered in the context of irrationality and arbitrariness as is plain from the preceding paras 24 to 31. That's the judgment actually, which we have forgotten. We are going on bias. The judgment is not on bias at all. And you are not giving an order on irrationality. Then how are you relying on that judgment? In any event, in the facts of the present case, the order of prior approval does not contain any reason why the decision taken by the council was irrational. Nor is there any basis for such a finding. The governor does not record that there is a certain relevant material. You also put a simple question. Which material does the governor say that the council, Malus, of which I was head not for that meeting, has missed out? Which Lokayukt report? Which report? It doesn't say so. Even assuming without considering there is apparent bias is a ground enabling, there exists no apparent bias in the present case where the chief minister not only recused himself not attending the meeting nor participated in any deliberation. Given that there is no declaration of law in MP, forget the last para. Now I'll just read that MP for a minute. Which volume is this? It is volume 2, Malus, case law volume 2, earlier one. Relevant at page 339. The page is the bottom of the page. Not marking. Why I'm arguing problem. Give me the mark lines. Give me blank things.
Page 3
is the same volume.
2. Yes, same.
Huh? This is volume 2.
Yes.
Why are you saying 339?
No, there is no 339.
This 339 changing here. Well, volume 4, 231.
Volume 4.
Yes, it's apparently the pages are not matching. Just giving it.
What case I
No, which case is this?
Page 213.
Which case are you showing?
339.
MP at 230 of, is it marked volume 4? Volume 4. Mark it volume 4. Yeah. Mark it. This is the latest one.
230 is Nabam Rabia. Earlier to that.
Latest today's volume. Last volume.
Today's volume.
230 is Nabam Rabia?
Yes.
Mr.
This
Solis
is
Farabchi has
210, 210. In today's volume, MP Special Police is 210.
I'm on the relevant portion, 230.
2?
230 is the relevant portion.
Yes. 230.
So this para your lordship has seen, Malus,
Yes.
already. Mr.
Yes.
Surya Sarabji not placed on record how, may I read this? Not placed on
Yeah.
record how Council of Ministers, collectively or the members of the council, individually were in any manner whatsoever bias. There is also no authority for the proposition bias can be presumed in such a situation. The real doctrine of likelihood also not be applicable. Right, Malus? This your lordship is read with me.
Yes.
Now, on the same analogy, in the absence of any material brought on record, may not be possible to hold that the action on the part of the council was actuated by malice. So far as plea of malice is concerned, the same must be attributed personally against the person concerned and not collectively. Well, the whole council is malice.
Yes.
My whole council is malice attached in a uniform manner. Even in such a case, the person against whom malice on fact is alleged must be impleaded. However, here arises another question. There are two competing orders. Now, this is where the thing changes. One of the council, another by the governor, one refusing to grant sanction, another granting. The council of ministers refused to grant sanction on the premise that there existed no material to show that R4 in each appeal had committed an offence of conspiracy, where the governor in his order was clear of the view that materials did disclose. An FIR was lodged in relation to the commission of the offence. Now, Malaz, this is enough, I would say, for your lordship to send any matter back saying council is wrong.
Matter back.
Any matter your lordships can say the council is wrong if para 28 exists.
Yes.
Anybody would say it, Malaz. I'll not read it. How is it that the council ignored a Lokayukt report of such detail, Malaz? It's as simple as that. And this case is being applied for the other point, for the bias point. This para 28 in my case applies in my favor. I hope.
Yes.
28 is omission of looking at Lokayukt. The omissions of looking at reports are by the governor in my case, today's case. What your lordship said there applies to the governor here. And we'll just see the report of the Lokayukt itself gives the material at the bottom of that page. Your lordship is ignoring everything at the council of ministers, and why your lordship not intervene? At the bottom of that page 230, the Lokayukt is quoted. The point is not that they are right or wrong. The point is they should have noticed it, dealt with it. They did not. And then 29 Malus, they say how high the Lokayukt office is.
No, 29, sir.
Yes.
Last 5 lines,
Yes.
30 and
30?
32.
Your lordship is on 30?
30.
Yeah. May I read the last 5 lines? It is now
Last 5 lines of 29.
Yes.
And
Now, while
third-
settle that refusal to take consideration relevant fact or acting on the basis of irrelevant experience not germane to the purpose would vitiate an administrative order. In this case, on the material disclosed by reward Lokayukt, it could not have been concluded that no case was made out. This is their talk about the council.
Yes.
Now,
Now,
it is well settled exercise of administrative power will stand vitiated. There is manifest error of record or the exercise of power is arbitrary. Similarly, if the power has been exercised in the non-consideration or non-application of mind to relevant factors, the exercise of the power will be considered manifestly erroneous.
now 32. Sir.
We have, well, just 31 for a minute also.
Yes, sir.
31. We have no hesitation to hold that decision was ex facie irrational. This is that manifestly irrational. This is about the council. Exactly these words apply to the governor with great respect. Whereas the decision of the governor was not. That's the competing thing your lordship is looking at. Is your lordship told after so many days of hearing which part of the governor's report tells you, which your lordship is reviewing, that this part of the council of ministers has omitted this? It's as simple. Well, we can all argue all these things. Has your lordship been answered that simple question by the governor? My lord is not sitting as a reviewing authority of the council first. First comes the governor.
No, of the governor. Yes, correct.
In a situation of this
32,
nature,
32 is what the apex court
the
would.
facts of these cases, the governor cannot act in. There would be complete breakdown of the rule of law. Be open for governments to refuse. This is in the light of that he must act at his
Yes.
discretion because he finds that the Lokayukt is missing. Does it say, Malaz, that governor can act at his discretion after Shamsher Singh downwards without giving a single reason as to what is wrong with the report in which he is acting at his discretion?
So everything boils down to the fact that he is entitled to disagree. The disagreement, yes, should be recorded. What is irrational in the note in the cabinet decision should be recorded. And a
the
decision should be
crux.
taken.
That's the crux.
That is all.
That's the crux.
Yes.
But Malaz, only with one caveat. Even the starting point should be a little cautious. You should not say that first thing is I can jump in. You must look at it cautiously in a harmonious manner and then say, look, I am not for a minute suggesting that your lordship has a case like this, where he has not looked at Lokayukt. I am the governor, I point out Lokayukt, and your lordship says, no, the council is right not to look at the Lokayukt. and the governor is wrong. I can never say that. But it's very, well, nothing is not rocket science.
Yes,
It's very
so-
commonsensical. And this also gives the court proper basis for review. It gives the proper test for review also.